So the next thing we're going to talk about is handling offers and offer modifications and counteroffers. Again, once we get a counteroffer from a seller that changes the original offer, it is a rejection of the original offer. All right, so we don't have to accept anything they send back as the buyer. All right, so any change to the original offer creates a counteroffer, and the NCAR, North Carolina Association of Realtors form, responds to the buyer's offer. Now, there's a form out there that will not commit the seller to a counteroffer. So this is a way to handle multiple offers without binding the seller, but it does reject the original offer, okay? What it is a form that, let's say I got multiple offers and I don't like any of them. So my agent can say, let's do a response to buyer. So what we're going to do is we're going to make a form out and we're going to say, hey, look, we received all of your offers. We reviewed them, but none of them are acceptable at this time. Please come back with another offer if you're still interested, closer to what's listed in the multiple listing system. Now, what we said there was really, we'll review them at that time, but we're not making a counteroffer. We just want you to do better. Now, what happens is when I send that form out, all of those offers are off the table now. I can't go back and accept one of those offers, but I'm also not committed to another offer. So if they send me back junk the next time, or not something that's not as good as I want it to be, well, I can reject those too, do another form. So there is a form that'll do that, and it'll leave me non-committed, which sometimes is used. Sometimes it's used, particularly with multiple offers. It says, hey, we're going to wait until tomorrow at 1 o'clock. If you would do me a favor before tomorrow at 1 o'clock, submit your highest and best offer for the property. We'll review all the offers at that particular time. And if they meet our acceptance, we'll let you know. Let's talk about shopping offers. Shopping offers. If I get an offer, I'm the listing agent, and Kimberly is the buyer's agent, and Kimberly sends me an offer. And I go, okay, that's a good offer, but let me see what I can dig up. Let me see if I can do a little better. So I know that Susan has brought a client in before, and they were interested in the house. What I can do is I can call Susan up and say, hey, I got an offer from Kimberly, and it's a pretty good offer. If you're interested, if your client's interested, now's the time. Otherwise, this may be off the market. What I can't do, unless Kimberly gives me permission to do it, I can't go to Susan and tell her the terms of what Kimberly's offer was. I can't tell them, hey, it was a full price offer, 30-day cash close, no inspection. And so I can't tell Susan that to say, hey, can your client beat that, right? Unless Kimberly said, yeah, Sam, go ahead. You can tell Susan what my offer is. And then I can. That's called shopping offers. However, let's be real here. You think Kimberly's going to let me do that? Right? She's not going to let me do that, right? She wants the house. Their client, she's going to protect her client. That's her job, right? So as long as I get their permission, I can do it, but I'm not going to get their permission. And that is what's called shopping offers, all right? So it says brokers may not share the material terms of a party's offer unless they have the express permission of the offering party, all right? So truthfully, things are what they are. I can be able to call other people and say, hey, it's coming off the market. So if you got something, then bring it. Bring your best, right? So I can still try to do that, but I can't give material terms of that offer. All right. In chapter 14, we're going to talk about bank financing, but what about seller financing? We can have seller financing. We can have what's called an installment land contract, or we can have what's called a purchase money mortgage. The installment land contract, what that is that's seller financing, all right? You might hear it say the land sales contract, the land contract, contract for deed, you might see it called. And what this is, it says that the buyer's going to give me a down payment. I'm the seller. There's no agents here. I'm the seller. Well, there could be agents, but the seller is going to do the financing. But the seller in an installment land contract is going to keep the deed until the property is paid off. Okay. So if we're going to pay, we're going to write something up, we're going to have the attorney write it up, and he's going to say, all right, 10 years, you're going to make X amount of dollars payment. After the 10 years, then you'll receive the deed. But if the buyer defaults at any particular period, he's going to lose his money. Okay, he's going to lose his money. So in that particular case, because he's not getting the deed, he doesn't have it. Okay, so the buyer's going to keep equitable title. The seller will retain legal title. Okay, and the seller will give him the deed when the final payment is made. Let's talk about equitable title and legal title. All right. Legal title obviously is the guy who handles the money, who's holding the deed, right? Now, let's say the buyer bought this in this year, 2023, for $100,000. That's what he owes on the house, $100,000. Okay, he's going to pay $10,000 a year for 10 years, and he's going to get paid off. All right, don't worry about the math not working out. Just play along. Now, in 10 years, is that house going to be worth more than $100,000? Does he have to give it to the seller if it's worth more than $100,000? No, he can go ahead and sell it for whatever money it's worth and keep the money. So it's building equity, right? It's building equity while you're paying it off. So you're only paying it off on the original price, right? Why would the sellers do this? Sometimes it's somebody you know. Maybe it's somebody who's had, life happens to everybody. Maybe they've had financial problems in the past, but they're good people, and you'd be willing to take a chance on them. And actually, it's a pretty good deal for the seller, because if the buyer defaults, the seller still keeps the property and the money that they've paid. So it's not a terrible thing, right? It's not a terrible thing. The hard part would be if we did what's called a purchase money mortgage, which means the only difference with the purchase money mortgage and an installment land contract, a purchase money mortgage means that I'm going to give them the deed at closing, and then they're going to make permanent payments. And then what will happen is if I have to foreclose on them, I got to go through the courts. Here, if I got to foreclose on them, they didn't pay, I'm not giving them the deed. They can take me to court, right? So in that particular case, that's what would happen. Now, they would have to keep up the maintenance and everything else, not the seller, but the buyer. All we're holding is the deed, but they're going to know the maintenance and the taxes and everything else on it. They have to pay for it as if they own it. Are they typically much more than a rent would be? If you can afford financing, buying is the way to go. It is so much cheaper to buy now than it is to rent. Square foot for square foot. If you can afford the financing and if you can afford the down payment, it is so much cheaper to buy now. Square foot to square foot. Right? So yeah, there would be definitely a benefit. Won't be much if they put a dump next to it next 10 years. No, it won't be. But, before I buy it, I'm going to have to do some sort of snooping around, right? Figure out what they're going to do. Now, like I said, there's no preset sales contract, so an attorney should be drafted and should draft the contract. You have to be, let them draft that contract. So there is no pre-printed one. Buyer pays all the taxes, assessments, HOA dues, insurance premiums, repairs. Buyer pays for everything as if he has ownership. The only thing he doesn't have is the deed. All right. And you often have a lower down payment and help buyers who have questionable credit. If you have low credit score, it's a way to help, right? It's a way to help. If the buyer defaults, though, if he doesn't pay, he may lose all the rights to the property as well as all previous payments made towards the property. Then it becomes basically a rental, and you're gone, right? And then you have to you'll get evicted. The next knock you hear on the door will be the sheriff's department. All right, so we talked about due diligence being options. we talked about a little bit about options. What happens with an option is a unilateral contract that somebody comes and gives a price to a seller. All right. So, and I'll read this to you, and then I'll show you. I'll draw it for you. The optioner gives optionee irrevocable right to purchase the property on terms in the option agreement. Specific price and terms are set with the agreement. And at some point, the option fee may be credited to the purchase price. But let's do this. Let me show you this. I'm a buyer. I'm an optioner. And these options are sold every day in multiples on Wall Street. You can buy options, shares in it, whatever. If I'm the seller, all right, I'm the seller, and I want $200,000 for my house. I am the optioner, 01, and I say to you, all right, Mr. Seller, I'm going to give you $2,000, but I need time. Today is January 19th. I need 6 months' time. So July 19th, I'm going to give you $2,000 for you to hold that property for me till July 19th. And if I come back before July 19th, you have to sell it to me for $200,000. And if the seller says, yes, I'll accept the money, the seller is stuck until when? July 19th, right? He's got to stay. He's got to sell that house for $200,000 by July 19th. All right, because he took this money. I'm the optioner still, and I go back to my office, and somebody says, another option trader says to me, hey, Sam, I'll give you $3,000 for that option. And I say, okay, give it to me. I didn't want the house that bad anyway. Can I sell the option? Sure I can. And I made $1,000 on the option, and I walk away. Does optioner number 2 have the right to go back and buy that house for $200,000? Yes. Yes, same option. And I can do it again if I wanted to. I can just go out and say, all right, hey, optioner number 3, 03, he comes in and says, I'll give you $5,000. As optioner number 2, you say yes. And now he's got until July 19th to sell it or to go back and buy it. So what do you think these optionors, these option purchasers, the optionees, are looking for? Anybody have any idea what they're looking for? They're looking and saying, all right, this house right now is $200,000. So I'm in it for $205,000 because I had to pay that $5,000, right? So as they're watching the market, they're hoping that this goes up in value. So at this particular point on July 18th, because they have to do it before the 19th, they're hoping that this is worth something about $230K. Somewhere in there, so it can turn a profit because it got cost to sell it. I'm going to go back and I'm going to buy it for $200. He has to sell it to me for $200. So what can I immediately do if he sells it to me for $200? Put it right back out of the market and flip it, right? And make some more money. I can make some money doing it. Now, what happens if I'm watching this and all of a sudden the prices are starting to come down? And now on July 18th, this house is only worth $195,000. If I wanted to go buy this house, how much would I have to pay for it? $200,000, right? So would I go back or I'd just let this thing expire, right? I wouldn't even go back. Just let it go. Take my $5,000 loss and walk away. So that's how the option works, and that's what they're looking for. All right. In the meantime, the seller made $2,000 to hold his house. Now, after this July 19th, on July 20th, the seller can sell it for whatever he can get. Option's over. Sell it for whatever he can get. Right? These could be on anything. These could be on anything and everything. Doesn't necessarily have to be new builds. Okay. Now, if you look at the Wall Street Journal at all, you'll see that they do this on corn, on real estate. They do it on gasoline futures. They do it on everything. They sell options just like this for everything. That's how it works. They just wait and see the price. They'll buy it for a certain month, and then they'll just see how the prices flow. If it's worth less, they'll pay less for it and make money on it. If it's worth more, they'll let it go. They'll let it expire. Does the seller have the option to buy out the option one option price? That would be debatable on the contract. That would be in what they would put in there. It would be an option, but there's no standard option contract. It's something that they may be able to put in there, but it's not standardized to say that. Okay, that's it. And that's your options, and that's how they work. So it's really not that technically crazy. It's actually pretty straightforward. They're not looking for anything scientific here. So the fees aren't earnest money. They're just time. They purchase time, right? That $2,000 I gave them up front, all I bought was time. All right, this means we have a binding contract. Now, two other things we could have are the right of first refusal and the right of first opportunity to purchase. If I give somebody the right of first refusal, let's say I have a tenant in the house, and I say, look, if I decide to sell it, I'll give you the right of first refusal. I'll let you, if I have a price in mind, I'll let you go first. If you want to buy it, I'll give it to you. That's basically the right of first refusal. A lot of times what's happening now with the right of first refusal is the fact that, like, condominiums on the beachfront. We were just talking about rents, right? If they make a heck of a lot more money renting out condominiums on the beachfront than they do collecting your HOA fees. So in the original master deed somewhere along the beachfront, they wrote in there, and I promise you it's in there somewhere, that they could invoke the right of first refusal if they saw fit. Well, now what they're doing is they're invoking this. So if I go to sell my property, my condo, to Carrie, let's say I'm going to sell it to Carrie. Carrie comes in and makes me a great offer. I have to tell Carrie, well, wait a minute, I have to go present that offer to the HOA. And if I go to the HOA and the HOA wants to match what Carrie offered me, I have to sell it to the HOA because they have the right of first refusal. They have the right to say, no, never mind. Go ahead and sell it to Carrie. Okay. So that's the right of first refusal. Now, if they want to buy it because they think they can make more money renting it, they'll purchase it from me and rent it out. Okay. So that's the right of first refusal. The right of first opportunity to purchase would be if I had a lease, if I had a landlord, or if I had a tenant and they wanted to buy it out, I would tell them if I'm going to sell it, you'll have the first opportunity to purchase. Right? And that's really all that is. Okay. Again, though, you want attorneys to draft those options, installments, or right of first refusal, right of first opportunity to purchase. You want the attorneys to draft those. Stay away from those if you can. So this is just a reiteration. It says that we should not be writing these contracts. We need an attorney to write those up. Consult your attorney, CYA, right? We're going to say it's consult your attorney, but you know what it means. All right, so let's go through the end of this. Due diligence, we talked about it. A backup offer, we just talked about. Installment land contract, we just talked about. The offeror is the person who is giving the offer, usually the buyer. Offeree is the person who's receiving the offer. And communication is key here, right? We have to let the other person know we've accepted it. You have to let the other person know. All right, in the chat box. True or false, Jimbo buyer submits an offer through his agent Frank at Go Realty to the seller's agent Jolene of XYZ Realty. The seller likes the offer and signs in the presence of Jolene. Before Jolene can take further action, Frank of Go Realty calls to rescind the offer. Does this legally terminate the offer? Yes, it does, right? She hasn't communicated it back. Got to call them back. Say, yeah, we got it. We signed it. Thank you very much. We're in. Or send them a copy back, whatever that is. What do we have if Jolene emailed the contract acceptance to Frank before he called to rescind the offer? Do we have a contract? I think we might. Yeah, at that particular point, we have a valid contract. Once she emailed it, it's accepted. That's communication, right? That's communication. What should a listing agent do if she receives a full price offer for her listing, an offer $5,000 below the asking price, and an offer $3,000 above the asking price. What should the agents do? Yeah, rule number one, folks. If you look in the rule books, present all the offers in any order, okay? It is absolutely imperative. Terms matter, okay? Terms matter. Plus, your job is you can't bind your client, so they have to see these, and you can't make those decisions for your client, right? So maybe it's closing dates better, cash, higher due diligence fee, all those things that are a part of this. Maybe that makes it more attractive. That $3,000 above asking price could be all based on financing. That $5,000 below asking price could be all cash, close in 21 days, which is pretty sweet. You may have to take a little less money, but you're going to get a quick deal, right? So in that particular case, you could number them. I mean, that's one way to do it. Sellers, much like buyers, change their mind like immediately. So, just know which one it is. So yeah, one would be the first one if that falls out, 2, 3, and so on. And then what we could do is call the other ones and say, hey, we've accepted another offer. Would you like to be in position as a backup offer in the event first one falls out, right? So then we can do that. We certainly are allowed to do that. Yeah, there you go. You put them in order. But if, let's say we take order number 1, we can call number 2 and say, hey, we've accepted a different offer, but we appreciate you giving us one. Would you like to be put into a backup position for in the event that number 1 falls through? And then they could become backup offer number 1 or backup offer number 2. Blank and blank can never be in the offer to purchase and contract. What were the 2 things we talked about? We just talked about them. Our compensation is 1. And what about the liability of the broker? Yeah, there you go. All right. Compensation structure for the agents is not going to be in there. And there cannot be a removal of liability for the broker, right? If the broker's wrong, the broker can get sued. He cannot do a hold harmless. True or false? Wanda Buyer is working with Gina of ABC Realty to purchase a home. Wanda makes an offer on a property listed by ABC. After Gina explains she'll be working with her as a dual agent. The offer is signed, accepted, and communicated to Gina. We now have a valid contract that Wanda cannot revoke. True or false? Right? She's a dual agent, so isn't she the agent of the other party? In that particular case, once she knows about it, she knows about it, right? So when a signed acceptance is communicated to the dual agent, it's the same as communicating it to the other party. She was there. Yeah, she was there when they signed it. Absolutely. True or false? A buyer pays $1,000 in due diligence and $3,000 in earnest money toward the purchase of the home. The due diligence period expired after 2 weeks. However, the seller commits a material breach by failing to deliver a marketable title. The buyer would be entitled to the refund of both the due diligence and the earnest money. True or false? Yeah, true or false? True. It's very true. All right. Only because the seller material breached, right? The seller absolutely said he wasn't going through it, or he couldn't deliver clean title, anything else like that. All right. Now, the buyer could also seek a refund of their due diligence expenses, not only their due diligence fee, but anything they paid to get the house inspected and appraised and things of that nature too. Go to court, try to get that. Which scenario best represents a legally binding contract once a seller submits a counteroffer to the buyer? A, the buyer's agent emails the seller to advise that their client intends to accept the offer. And B, the seller receives a digital signature of acceptance from the buyer. Yeah, we want affirmation. We don't want the intend part. It's got to have a signature on it, right? Because the seller can still say no, and you've communicated it back. You're not allowed to bind your seller, right? We're not allowed to bind our agents. There's only an intent here. Why not A? And I think I just explained that. In an installment land contract, the buyer has what type of title and the seller retains what type of title until the final payment is made. What kind of title does the buyer have? Equitable, right? And what kind of title does the seller have? Legal. He has the legal title. Yes, absolutely. The buyer has equitable title. Seller has legal title. Barry buyer has submitted an extensive repair list to Sarah seller during the due diligence period, and Sarah agrees to make all the repairs. However, Barry has a change of heart and wishes to terminate the contract before the due diligence period expires. He will receive his earnest money back as a result. True or false? Yeah, it is very true. The buyer can terminate the contract up to the end of the due diligence period for any reason or no reason whatsoever. Any reason or no reason whatsoever. That's weird. Every time I go to the end of my chat box, it goes back up to the beginning. My Zoom has been going like nuts. Buyer and seller have verbally agreed for the seller to leave their washer and dryer, although this is not included in the offer to purchase and contract. The seller later decides to take the washer dryer with them to their new house. The buyer is distraught and wishes to terminate the contract. The seller will be entitled to the contract remedy if the buyer breaches the contract. True or false? I'm hoping you're all saying true, right? All right, yeah, it wasn't written in the contract, all right? It was true, it was true. So at what point do we have a contract here? The seller signs an offer to purchase and contract as written and mails it to their listing agent. They also call their listing agent to notify them. The listing agent immediately calls the buyer's agent to notify them of the contract acceptance. Later that day, the buyer's agent calls the buyer to communicate the acceptance. At what point does this contract become valid? And it technically comes valid when the listing agent calls the buyer's agent to notify them of the acceptance. That's where it is. That's when it is, okay? So it would be C when they call it. All right, that's it. That's it for chapter 10. North Carolina is a title theory state, okay? South Carolina is a lien theory state. So what do I mean by that? So you heard Joe talk about it. South Carolina, our sister state, holds a lien on your property. The bank is going to give you a mortgage and they're going to give you the deed at the same time, okay? So there's two parties here. You got the bank and you got the buyer, all right? So in this particular case, two parties, the mortgagor and the mortgagee. The borrower holds both legal and equitable title. They have the deed and they have to make payments as they go. If South Carolina wanted to repossess your house because you didn't make payments, they would have to go to the court. And they would also have to bid on, there's a foreclosure auction the first Monday of every month at the courthouse in, I know the county down here, the courthouse in Conway. All right, you want to go to a foreclosure auction, you can go there and you can bid on a foreclosure. But the banks are there too, trying to bid on their own properties. So that is a lien theory state. What you have to know is the title theory state, okay? And that is a three-party instrument. You're going to get a deed of trust. You're not going to get a mortgage. It's going to be a deed of trust, okay? So you have the lender, you have the borrower, and you have the trustee who's going to hold this deed of trust. And the borrower is going to ask for money. The lender is going to send the money. But the lender is going to write a deed of trust, and they're going to give it to a trustee, a third party. And that trustee is going to hold that to make sure that you make payments. So the borrower holds equitable title. The house, obviously, like we said before, with installment land contract, the house value is going up, and that's the buyer's. The bank holds legal, the trustee, holds legal title because they're holding the deed of trust. The bank is just getting their payments, but technically the bank has a dotted line relationship with the trustee. They have what's called power of sale foreclosure. And power of sale foreclosure is this. If you don't, Mr. Borrower, make your payments, all the trustee has to do is set up an auction, a public auction, and sell your property. they do not have to go to court to sell your property from you due to that power of sale foreclosure. You miss your payments, they're going to give you notice. You're either going to have to pay it all in full, or they're going to sell your property. Going to have the auction. They don't have to go to court. They're not going to take you to court. And it happens rather quickly. It happens rather quickly. North Carolina is this title theory state. So whichever one the bank holds, that's the theory. So if the bank holds the title, in this case, we are a title theory state. In South Carolina, the bank holds a lien against your property. They are a lien theory state. This instrument that you get, in this particular case, right, mortgage loan, you're going to ask the bank for money. And then you're going to say, this promissory note says that you are promising to pay. You're signing, all right? Give me X amount of dollars, Mr. Bank, and I will sign that says that I promise to pay you back. So, okay, that's good. The next step to that is the mortgage or the deed of trust. You're giving the bank the mortgage. And the mortgage says, or the deed of trust in North Carolina, says that if I don't repay, this is the second part, if I don't repay, then you have the right to take the house from me. So the first part is I promise to repay, that's the promissory note. And the second part is, Mr. Mortgage Company, I will pay you back, and if I don't, you will take my house. That's called hypothecation. Hypothecation. We're going to keep control of the house. We're going to keep holding the house, but if I don't pay, you can take it. All right. Now, heads up. Who's giving who the mortgage? Who's the mortgagor and who's the mortgagee? Borrower is the mortgagor, and the bank is the mortgagee. Remember, we always said that the person who's receiving it, they are the EE, right? Well, in this case, the bank is receiving it. So the bank is the mortgagee. So you're not the mortgagee. People get that one confused all the time, right? People get that one confused all the time. So the bank is the mortgagee. You are the mortgagor because you gave them the mortgage. Hypothecation, keyword there, the act of pledging something without giving up ownership of it, without giving up possession of it. It's called hypothecation. All right. And in North Carolina, you also have not a mortgage, but a deed of trust. A deed of trust that's held by the trustee.
If you like this video, feel free to share it with a friend. For more real estate education content, please subscribe to the channel. From all of us at Seacoast Real Estate Academy, thank you for watching.